We're on the record.
All righty. This is the 2 p.m. calendar for March the 22nd. We're starting slightly early so we can do one case before we do all of the other cases. First, can the county attorney who's on the line enter their notice of appearance or just state their name?
Yes, Your Honor. Good afternoon. Patrick Johnson from the Pinal County Attorney's Office for the state.
Good afternoon, sir. All right. So this is the initial appearance. What we're going to do today is tell you what your charges are, appoint counsel to represent you, give you some court dates. All the court dates and the release conditions be in writing. You'll be given a copy of those. But that's what we're doing today. Please state your name and date of birth.
Christopher Brett Eves, born on July the 22nd, 1975.
Thank you, sir.
I'd like to make one statement for the record. I was never.
Hold on. Okay. You can make whatever statement you want, but let me just tell you one thing.
Okay.
This is being recorded, and everything that you say is being recorded and could be used against you. But you're free to say.
I've never been Mirandized and was never Mirandized and told the charges that I was being brought here for and detained. So I asked the officers on many occasions, and I still haven't seen counsel. So I was interviewed by a prosecutor, and it sounds like another prosecutor on the line. I don't have counsel.
You weren't. I don't know if you were interviewed by a prosecutor, or you were interviewed by somebody from pretrial services.
Yeah.
Pretrial services. They just want to get information from you to see whether or not you're entitled to an attorney, whether or not you're Mirandized after you were arrested. Miranda only applies to in custody interrogations. And
Correct.
if they didn't Mirandize you, then your attorney can let you know that any statement you may have made without being Mirandized, if you were in custody, could be suppressed.
They also subpoenaed me, or they subpoenaed a number of things, including a search warrant for my person without Mirandizing me.
Well, they don't need to Mirandize you for that. But
they need to Mirandize me to detain me, they said, and not arrest me. I asked them on several occasions, and that was the case. I just wanted to say that.
You've made your record, and that's fine. I'll tell you exactly what you're charged with now, because this is what the initial appearance is for. You've been charged with 2 counts. The first count is murder in the first degree. It's a Class 1 felony. Your second count is burglary in the first degree, which is also a Class 2 dangerous felony. So those are the 2 charges that you have against you at this time. I have found you to be indigent. I'm going to appoint the public defender at this point to represent you. You're free to hire your own attorney at some point in the future, but at this point, the public defender
I'm not indigent. I don't have any problem finding a place to stay. I have a house with...
Indigent, I'm talking about whether or not you can afford an attorney on these charges. At this point, I'm finding you indigent. I'm appointing the public defender. You are always free to hire your own attorney.
I hired Mick Lavelle, and I've been trying to get a hold of him, but no one afforded me a phone call. So I've been trying to reach counsel since this began.
All right. We'll note that.
Okay.
All right. Now done that, Mr. Johnson, do you want to be heard on release conditions, sir?
Yes, Your Honor. Your Honor, the state is asking the court to hold the defendant non-bondable at this time. It's the state's and law enforcement's belief that it is a danger to the community as well as the next of kin in this case. We're asking that the court set a Simpson hearing within 10 days. But at this time, based on the investigation in the case and what the Phoenix Police Department has learned, it's the state's belief that the defendant poses a risk to the community as well as family in this case.
How so?
Your Honor, first of all, he is charged with the murder of his brother. Based on the investigation, the defendant lived with his parents. According to the investigation, the defendant went over to the victim's house early yesterday morning and shot the victim, fired multiple shots. He returned to his house where he lived with his parents, and Phoenix Police car, they found multiple loaded weapons in the defendant's car. It's the even though there was only one victim in this case,
they found multiple weapons in what car?
In the defendant's car. There were.
Which car is that?
I thought that was the court asking. So
no, that was the defendant asking.
okay. All right, I thought the court asked me how so, and that's why I was explaining. I apologize for that. But anyway, based on the evidence in this case, if the court has any questions, I would be free to ask them.
I would like to post bond, be able to address many of these issues and seek counsel.
All right. Let me just do one quick thing. All right.
I would like to post bond and seek counsel, just for the record.
I know, and
Okay.
This is a close call of whether or not you should be held without bond or not.
Okay.
I'm going to do one quick thing. All right. I'm going to set bond in this case.
Okay.
But first I have to let the computer let me do it. I don't know why it's not letting me edit it. Okay. Okay, there it goes. All right, sir. I mean, it's going to be a very high bond. Bond is set as a cash-only bond in the amount of $1,500,000. If bond is posted, you'll be subject to pretrial services, electronic monitoring, and be subject to house arrest. You're not to return to the scene of the alleged crime. You'd have absolutely no contact with the alleged victim. That would include relatives of the victim. At this point, since the victim was your brother,
the mother and father, they're my mother and father, not anyone else.
Mr. Johnson, you want to be heard on that because the victim. Go ahead, sir.
Yes, if the defendant does post bond, the state would ask that he is not to have any contact with his parents, who are the next of kin of the victim. I understand that the defendant lived with them. That was part of the state.
That is the address on my driver's license, and that is where I've lived for a very long time.
However, they are the next of kin of the victim, and the state would ask that the court impose that he is to have, if he posts bond, he is to have no contact with them. We would ask that a sheriff's deputy
on what basis?
Escort him to the house.
Stop for a second, Mr. Johnson. This isn't a debate. Mr. Johnson is speaking. You don't speak at the same time he is speaking. All right? Sorry to interrupt you, Mr. Johnson.
No problem.
Go ahead.
But the state would ask that part of the release conditions is he is to have no contact with his parents, who are the victim's parents. They are the next of kin. They have victim's rights in this case. And at this point, the state has had no indication that they would like to waive that no contact. And we ask that if he does post bond, he be ordered to have no contact with his parents at all.
I ask again why that would be the case and what they have objected to in terms of me living in the home that I've lived in and is the address on my driver's license for greater than 3 years. It's a simple question.
All right. I have ordered that he is to have no contact with his parents, who are the next of kin of the alleged victim. He may have one civil standby to obtain any of his personal property. So, sir, if you post bond, you would be allowed to go to your parents' home one time with the police only to retrieve any personal property.
That is my home as well, just for the record.
Okay, that's fine. We do this all the time.
Okay.
But I'm going to go over the other release conditions with you. We started them. You're not to return to the scene of alleged crime, which was apparently your brother's home. You're not to initiate contact with any alleged victims. The definition of victim does include your parents, because they are the next of kin of your brother. So I've stated this on the record very clearly, and it's also in the release order. You're not to have any contact with your parents. You're not to have any contact with any witnesses. You're not to initiate any contact with any arresting officers. You're to possess no weapons of any type. You're not to possess any drugs without a valid prescription. You're not to drive without a valid driver's license. And you would have to provide court with proof of your local address. Your next court date on this case will be a status conference on March the 27th at 8:30 in the South Court Tower in downtown Phoenix, with a possible preliminary hearing on March 31st at 8:30 at the same location.
Are you going to record these for me? I didn't get any paper or pen.
You'll get paperwork.
Okay.
The officer will give you some paperwork.
Thank you.
So the court dates and all your release conditions are on the paperwork.
Okay.
But you're not going to be released at all unless you post the $1.5 million cash bond, and then you would have to have an ankle monitor with house arrest. Do you have any questions, sir?
I do. I would like to seek counsel even for this proceeding, for the record, and I would like to know exactly why I have not been Mirandized.
Once again, Miranda is just a warning to let you know that you have the right to remain silent.
When you're arrested.
Some people are under the misperception that they don't Mirandize you. Somehow the charges mysteriously go away. The only thing Miranda does is if you make a statement when you're in custody and you haven't been Mirandized, that statement can be
any evidence
suppressed.
Gathered is definitely already brought about.
The evidence gathered has nothing to do with Miranda.
The Fifth Amendment outlines the Miranda clause, and it's clearly brought about that you should feel secure in your person belonging to home, your Fourth Amendment. So yes, I do know exactly what I'm talking about, and I was never Mirandized, and I would like to seek counsel.
And you absolutely have the right to seek counsel. Anything further from the state?
No, Your Honor. Thank you.
All right, we're adjourned on this matter. Thank you. We're off the record until the